Yes, it's a great pleasure. And the topic of my talk today, legal orders of non-recognized entities in Ukraine, lawfare in action. And I think this topic quite timely to be discussed with international and European legal community. And I look forward to hearing comments, possibly some corrections and views with regard to this quite complicated and actual topic. The structure of my talk is going to be that I'm going to discuss the phenomenon of lawfare in modern international law or in modern international law, history, background of separatist movements in the Donbas area of Ukraine. Then I will look at prerequisites and chronology of establishing non-recognized areas in the Donbas area of Ukraine, as well as I will analyze the status of non-recognized areas in Donetsk and Lugansk under international public law. And also we'll look at just, of course, generally, because time is quite limited, at foundations of legal systems of these so-called republics. And we'll also pay some attention to the level of protection of human rights on the territory of so-called Donetsk and Lugansk Peoples Republics. And in the end, I will share my views regarding this subject matter. When the notion of lawfare is a pretty new one, it's dynamic, it's evolving, and it's of course a subject of discussion. It's, in my opinion, it originates from not a long time ago, from 1975. International law scholars Neville Yeomans and John Carlson published a paper identifying this phenomenon as a trend when legal systems are used as a refinement of combat. So basically, when legal systems and legal knowledge can be used for warfare purposes. So it was one of the first effects of, and also tries to show, to identify that international or just also mainly international public law can be used for purposes of warfare. One of major and most notable figures who has been working with the notion of lawfare and promoting this notion is a US scholar, legal scholar, and also former General Charles Dunlop, who published several articles and papers on the subject matter. And he identified this phenomenon as a process when there is a disturbing evidence that the rule of law is being hijacked into just another way of fighting lawfare to the detriment of humanitarian values as well as the law itself. And Mrs. Goldstein, so soon after, I think, put forward probably the most useful and successful if we can say so, definitions of the lawfare. In her opinion, it's a wrongful manipulation of the law and legal systems to achieve strategic military or political ends. In my opinion, again, I think it's probably the most substantive and right definitions. So it provides and gives clear negative connotation to this notion. However, today there is a discussion about whether within academic community whether lawfare can be actually used as a politically correct notion, because law and warfare blended together can produce some questions of a moral nature and value, whether it can be blended together. And therefore, some scholars propose to use a definition called malign legal operation. So basically, it's considered that in the course of any military operation, warfare, manipulation with the law, in particular international public law, constitutes a very important part of it in order to justify, explain, and to identify goals and objectives what a fighting party wants to pursue. And indeed, if we come now closer to the recent pan-European war which is taking place in my home country in Ukraine, this phenomenon, whether malign legal operation or lawfare, is being openly applied and consistently applied because Russian President Putin has been consistently and actively using and referring to international public law as well as history, in particular history related to the region where lawfare could and eventually was unleashed as a part of a general information campaign, propaganda campaign, as well as justification for the invasion. On the eve of the invasion on February 24th, invasion to Ukraine, President Putin recorded and delivered quite an extensive sort of lecture. And it was not the first, it was one of many lectures delivered mainly to the Ukrainian as well as Russian nations. And the main part of this lectures, in particular lecture delivered or talk delivered on the eve of the invasion, related to the analysis of various aspects of international public law as well as history in order to openly justify the invasion. Furthermore, basically, President Putin used and manipulated with some notions which are quite crucial for the entire campaign, like the aggression. In his opinion, it's not aggression, but on the contrary, self-defense. And also genocide. Genocide, again, was used in a particular, it was one of the reasons to unleash a special military operation, not war. And genocide was a justification for such an operation. And there were many, many references to this legal and political phenomenon. However, in order to understand and comprehend usage of lawfare on a particular case study, I would like to draw your attention to the issue of the non-recognized entities in Ukraine, which appeared 8 years before the invasion, current invasion, in year 2014. I'm as a national of Ukraine, and I'm also native to the Donbas area. I spent my all childhood and the best young years in the city of Donetsk. So I take this topic particularly close to my mind and heart. So just to introduce and to convey the distinguished audience to the subject matter, I would like take some time and explain and give you some historical prerequisites of the appearance of separatist movements in the Donbas area of Ukraine. On this map, you can see in a red color, it's actually colored in without distinguishing the border, but it's a territory of two regions of Ukraine, namely Lugansk and Donetsk regions, which is now the scene of bloody conflict and one of the major objectives of the war. However, before we look at the prerequisites of appearance of separatist movements within this region, I would like to highlight certain historical events which took place and could partly explain the recent events. So from ancient times until 18th century, the entire Donbas area was, as well as other nearby areas, were uninhabited. It was a steppe which was mainly populated by Normans and used in constant movements of Norman nations and armies which were located nearby. And it's only in 18th century when already it became, this steppe area was under the jurisdiction of the Russian Empire. First traces of coal were found, and the quite ambitious industrialization campaign started. And for this purpose, the Russian Tsar, at that time it was Alexander II and Alexander III, they decided to invite Western, mainly European entrepreneurs to actually compete for tenders and to start steel mills and to found and to launch coal excavating and mining activities. And most of the prominent coal mining and steel mill sites were found by Welsh as well as Belgian entrepreneurs in the end of the 19th century in the Imperial Russia. Still now, many traces could be found in names or some historical or cultural sites in that area. When the Great Bolshevik, as it was called, revolution took place in 1918, and when the first independent Ukrainian so-called Centralna Rada Republic was found, the Soviet Moscow government decided to set up a republic. Actually, it was a kind of an predecessor of the current separatist republics called Donetsk Kryvyi Rog Soviet Republic. It existed only for about half a year. It was led by quite notorious but strong-minded Bolshevik leader Artyom, and still now quite a few towns and cities and streets in the area are named after him. There are quite a few of monuments. And it was a republic to actually compete and to promote Soviet Bolshevik regime in 1918 in a time of bloody civil war. And once the Soviet power was established throughout Ukraine, this separatist republic, or possibly it's difficult to identify its origin. It certainly was instigated by the Soviet and at that time Bolshevik Moscow, ceased to exist. So it served its purpose, and then it was actually terminated. And then from a year 1918 until 1991, Donbas, namely Lugansk and Donetsk regions, belonged to the so-called Ukrainian Soviet Socialist Republic and constituted a main industrial heart of this republic and of the entire Soviet Union. So my message here is that there were no major territorial disputes, no major territorial conflicts around this area, with exception to the existence of this short-lived Donetsk Kryvyi Rog Soviet Republic. And all the time, Donbas, actually in contrast to the dispute around the annexed Crimea, was belonging to the Soviet Ukrainian Socialist Republic and then independent Ukraine. There is a picture of my native city, Donetsk, how I remember it and how it used to be. I would like on this slide to highlight certain specifications and features of this region in the time following the Ukrainian independence in 1991. And I would like, it's a central square in front of the drama theater. And it was one of the most festive sites of the Euro 2012, which took place in the city of Donetsk. So since the Ukrainian independence in 1991, Donbas, in particular the city of Donetsk, became political, industrial, and sport center and hub of entire Ukraine, with a very close integration into European and world economy. By the way, my first Jean Monnet module in EU law, I started teaching in Donetsk, being an associate professor at the university there. And Donetsk also hosted the very first center for Euro-Atlantic integration in Ukraine at that time. Furthermore, Donbass political and economic elites played crucial and leading role in Ukraine and produced most influential and most prominent political leaders in the time of independent Ukraine before the war. One president, but of course the most unsuccessful one, Viktor Yanukovych, but there were about up to 5 prime ministers. And also Donetsk was a hub and center for strongest majority and opposition political parties. One of the most known and notorious one is the Party of Regions. So certainly after Kiev, Donetsk was a center of political life and political influence in Ukraine. Some names of some Donbas oligarchs like Akhmetov, Kolesnikov, and others are quite known, and they had been keeping top Forbes position in Ukraine and beyond. So before the conflict, before the war, in the year 2013, Donetsk was the second richest city in Ukraine with world-class airport, sport facilities, and business opportunities. So in my opinion, again, as a native of the city, there were no economic, political prerequisites for then to appear separatist movements in this region. Just there were no simply reasons for it. However, what happened shortly after can be, and I would like to highlight. So, so first of all, I would like to describe the status of current status of non-recognized areas of Donetsk and Lugansk republics, so-called republics, under international law for your attention. So officially, of course, Donetsk and Lugansk Peoples Republics are considering themselves as non-recognized states. So states, so they consider themselves, of course, they would like to be full subjects of international law. However, they are not being recognized by majority of countries in the world. Hitherto, the so-called Donetsk and Lugansk Peoples Republics, they received formal recognition only from 4 countries. The Russian Federation on February 21st this year, and the recognition actually was a prerequisite for the invasion, as well as by the non-recognized republics themselves, South Ossetia and Abkhazia, located in Georgia. And just a few days ago, Syria recognized these two republics as subjects of international law. And today, we've got news that Ukraine terminated diplomatic relations with Syria in response to this action. Most of the people who reside in the territory of Donetsk and Lugansk Peoples Republics, they enjoy multiple citizenship. Most of them originally are Ukrainian citizens, and many of them keep and continue keeping Ukrainian passports. But they also were forced and encouraged to accept local citizenship. Both republics introduced their own passports, own citizenship. And later on, there was a wide-scale program to take Russian citizenship. So basically, most of the people residing there, they enjoy at least triple citizenship. And 2 of the citizenship is Russian and Ukrainian. Ukraine considers these territories as temporarily occupied. People who reside on these temporarily occupied territories are encouraged to move to Ukraine as soon as possible. and to obtain a status of displaced people. And they're entitled to a full package of social security payments, of course, in line with Ukrainian law. However, it hasn't worked in all the cases, because most of the people who remained in the territories of Donetsk and Lugansk republics, they're elderly people, retired, and for many reasons, health and family reasons, they're not willing, either not willing or cannot physically leave their homes and to move as temporarily displaced people on the territory of Ukraine. Furthermore, since Ukraine concluded the association agreement with the European Union in 2014, and which entered into force in 2017, Ukrainian nationals residing in Donetsk and Lugansk republics actually enjoy the same freedoms as the Ukrainian nationals, and they can they can enjoy visa-free regime, as well as access to some of the freedoms of the EU internal market. What is the position of the EU and other international organizations with regard to labeling the status of the Donetsk and Lugansk People's Republics? And for example, the European Union traditionally been very politically correct and cautious in its definitions, labels these territories as non-government controlled areas of Eastern Ukraine. It's how it refers to it in its documents. And I presume same definition could be applied to the newly occupied areas. So I would like to remind that the territory of the Donetsk and Lugansk republics before the invasion constituted up to 10% of the Ukrainian territory. Now the Russian Federation occupies around 20%, so twice more than it was before. So basically about the legal systems, I think I maybe missed some. Yes, I missed a slide, and I would like to actually refer to it because I found this slide. Before I'll move further, I would like to offer you a chronology of establishing non-recognized areas of Donbas. So my message in the previous slide was that there were no prerequisites of the appearing of separatist republics in the territory of Donetsk and Lugansk. And again, as I argue, the entire campaign and procedure to which resulted in their appearance was a well-organized warfare operation with a well-prepared engagement of qualified security agents from mainly from the Russian Federation side. So in order to prove my presumption and statement, I would like to introduce you to the chronology. And this chronology shows that two separatist republics managed to appear, and not only to appear, but also to set up their own legal systems in a critically short time, which certainly prevented any engagement of a population residing there, civil society, and wider audience into discussing of a major documents, including the constitutions of these republics, and basically was done as a blitzkrieg military operation. So the establishment of these two separatist republics was triggered certainly by two major events: the so-called Revolution of Dignity in Kiev in February 2014, when President Yanukovych fled the country and ended up on the territory of the Russian Federation. And consequently, quite soon, Russia annexed Crimea in March 2014. Pretty soon, already on April 6, 2014, pro-Russian protesters already started to gather in the center of Donetsk and Lugansk. And most of these protesters were not local people, but people brought by buses from the neighboring Russian regions. And they all started wearing Russian banners and started seizing governmental and law enforcement buildings in Donetsk and Lugansk. After seizing these buildings, and by the way, it must be admitted that law enforcement bodies, Ukrainian law enforcement bodies, decided not to intervene and basically left these buildings and let them to be occupied by these protesters. Almost on the next day, on April 7th and 8th, so-called people's councils, mainly parliaments and governments of the People's Republics were formed. They were formed by way of conducting open air elections within the crowd in front of the governmental buildings, and names and of MPs and leaders were proclaimed and publicly supported in these crowds. Soon after, already on April 7, 2014, people councils, newly elected people councils, proclaimed the acts of statehood and sovereignty of two republics, and simultaneous referendums on self-determination took place already on May 11th in Donetsk and Lugansk. Of course, there were no observers attending these referendums. Official numbers showed nearly 80%, 90% support for the independence, and it was a legal base for further activity of the so-called People's Republics. By the way, on May 24th, same year, there was a proclaimed confederation called Novorossiya, which is another subject of history debate and which is now already became actual again in light of the occupation of the southern parts of Ukraine. So effectively, after proclamation of and so-called referendums, Ukraine lost control over these regions and launched so-called anti-terror operation. On the picture on your right side, you can see quite a notorious figure, and he's the best example of how actually military resistance started. Igor Girkin, he's a former FSB, Russian security force officer who entered the territory of Ukraine in May 2014, and he formed first paramilitary units which under his direction started attacking the Ukrainian army. And it was a start of active military actions on the territory of the Donbas area. So now we'll go further and we'll discuss briefly legal systems of so-called Donetsk and Lugansk People's Republics and their major characteristics. So immediately, if we have discussed with you the chronology. So first proclamations and riots took place in early April 2014. Already on May 14th, the constitution of Donetsk and Lugansk republics were adopted. The constitutions appeared from nowhere. There was no public discussion about its content and objectives. It was just initiated within the people's councils, which successfully adopted them. And these constitutions, after some minor and major revisions, are still in place. These constitutions are quite classical. They comprise of 10 chapters, 86 articles. And of course, they refer to the constitutional order, protection of human rights and freedoms, separation of powers, legal status of heads of the governmental bodies, judiciary, prosecution, and so on. I would like to highlight several features, most notable features of these constitutions. And first feature, what legal analysis brought us to quite a surprise, that the text of this constitutions almost word by word replicates and mirrors the text of the Constitution of the Russian Federation of 1993. So basically, what has been done, there was a text of the Russian constitution taken as a sample. It was corrected in order to take into account major specifics or related to Donetsk and Lugansk republics, and it was taken as a main body text for these constitutions. So I think it's quite important observation. Next, specific features of these constitutions, which could be worth of our attention. Values. The constitution contains so-called ideological freedoms. So of course they refer to the necessity to protect human rights and basic freedoms, so without references to international European legal documents, but they refer to some ideological issues, so-called ideological diversity, like not only multi-party system, but also political diversity, and it's considered one of main assets of this constitution. Third, the constitutions of Donetsk and Lugansk republics offer dual official languages that are Russian and Ukrainian, but it doesn't provide any guarantees to enforce this right, because basically it proclaims, but Ukrainian officially is a part of the curriculum, but it's, as you can guess, it's not many nationals and people residing on these territories dare to study Ukrainian in that time and recent circumstances. Fourth, the constitution of Donetsk and Lugansk republics fail to specify the role of international law, international agreements, and principles of international law within their legal systems, which is actually one of the major differences with the Russian constitution. The Russian constitution, especially of 1993, contains quite far-reaching provision on the application of international law and principles of international law, but constitution of Donetsk and Lugansk Republic failed to do so. There are laws which are called on application of international agreements, but they're already secondary laws. So constitution omits these issues. And last, the constitutional orders of Donetsk and Lugansk Republic establish quite strong presidential republics, which resemble, of course, powers of President of the Russian Federation. Now I would like to mention a situation related to the protection of human rights on these territories. So the European Court of Justice, European Court on Human Rights in Strasbourg considered already several cases related to the protection of fundamental human rights by Ukrainian nationals who reside within these territories. And the court issued that applicability of the European Convention on Human Rights on this territory is defined not by rules of international law, but by the European Convention on Human Rights. It means that any country party to the European Convention is responsible for the application of the convention within all its territory, conditional on the facts. So basically, it imposes a responsibility on Ukraine, but also on Russia. And it was confirmed in several cases, like Ilescu, but it was more on regarding the Transnistrian territory, but it could be as a matter of analogy used here, as well as cases Caesar and Chlebnik, which related exclusively to the Donetsk and Lugansk republics. So in order to comply with judgments of the European Court of Human Rights, the Ukrainian parliament adopted a law on the temporarily occupied areas, and it confirmed its jurisdiction and commitment to ensure protection of human rights and access for judiciary. However, the Russian Federation, as it was stated already in Ilescu case, is vested with the responsibility to compensate any material and non-material damage caused by the occupation of these regions in accordance with norms and principles of international law. Furthermore, Provisions of the Donetsk and Lugansk constitutions, they impose and ban so-called one of the ideological values, what I was referring to, which is called extremism. And one of the most exemplary issues of persecution, violation of human rights, it was imposed ban on activities of internationally based Christian denomination called Jehovah's Witnesses. So basically, following analogical judgments by the Russian Supreme Court, the Donetsk Peoples Republic Supreme Court has replicated that and mirrored the decision and judgments of the Russian Supreme Court and prohibited banned activities of this church and recognized it as extremists and confiscated all their property on the territory of so-called republic. So it's a very interesting event showing that on issues related to human rights, Supreme Court of Donetsk and Lugansk republics prefers to follow practice case law of the Russian courts, and it may go as far as to ban activities of religious groups or certain organizations. And last but not least, an issue which is now very actual is the fact that criminal codes of the Donetsk and Lugansk republics, they allow death penalty, capital punishment for certain crimes, including crimes for military actions, especially mercenaries. And on this pretext, the Supreme Court of the Donetsk People's Republic recently issued a death penalty with regard to the captured British and Moroccan prisoners of war who are officially members of the Ukrainian army. So international community, namely the British government, I'm not sure about the Moroccan government, they officially require it, questioned whether the Russian government can influence and assist in release and lifting this sentence with regard to a British national. And the answer from the Russian Foreign Office, I think, was that government of the UK better contact and directly communicate with the government of the Donetsk People's Republic on this matter. And my concluding remarks, which I would really like to discuss with the audience and answer questions on this matter. So launching and instigating non-recognized entities is certainly a part of modern hybrid warfare and can be initiated by security services under certain preconditions in any regions of the world. Legal systems of the non-recognized entities can be exported either from existing sponsoring countries of these secessionist and separatist movements or from historical legal systems on pretext of a specific ideology. Like in case of Donetsk and Lugansk, what's I think it's very important to highlight, criminal legislation, criminal codes were adopted from the Ukrainian, from the times of the Ukrainian Soviet Socialist Republic, basically from 60s of the last century. So, and it was again based on certain ideological reasons. So basically a legal system was founded on already non-existing criminal legislation from the Soviet times. Legal systems of the non-recognized entities may serve specific purposes of hot and hybrid warfare. And for example, the case of application of death penalties in Donetsk, it's a very good example of it. So basically it's, since Russia still doesn't apply death penalty, so there were some calls to do it. Basically it's a part certainly of hot and hybrid warfare with regard to the members of the Ukrainian army. In the most cases, legal systems of the non-recognized entities cannot ensure protection of human rights in line with contemporary standards because nationals residing on the territories of these non-recognized entities basically don't have any physical and legal means to protect their human rights within international institutions. They must certainly leave the country, or they couldn't risk protecting their human rights within the local judicial system. It could imply certain prosecution, like it was done in the case of Jehovah's Witnesses. Legal systems of the non-recognized entities are usually dynamic and reflect current and future geopolitical situation. So it must be acknowledged that these systems are not sort of static. They are inclined to be changed, how it suits basically political elites within the non-recognized entities and so-called a patron state, sponsor state for such an entity. So these are my major conclusions and observations, and I look forward to hear your comments and, of course, comments of my colleagues. I hope I'm still within my time limit. Sorry if I exceeded it a little bit, and I give the floor to the chair of our meeting.